Welcome to January 11th, Tuesday, 4 p.m. Eastern Standard Time. We're here for some exciting stuff. Finally understanding what these 2022 START group practice rules are with a tremendous expert in the area, Lester Perling. Most of you know Lester pretty well. Lester was a hospital CEO. Lester's a scholar. And Lester is a healthcare lawyer with the Nelson Mullins law firm. The Stark laws that we're going to talk about prevent a medical practice and doctors in the medical practice from referring designated health services to themselves or their practice or billing for these designated health services unless these complicated rules are complied with. And if a group was in compliance last year or the year before or the year before that, you cannot be sure that you are in compliance now unless you and your healthcare lawyer have reviewed these rules and your situation. The rules are complicated and they're tricky. You can understand most of them, maybe if you're lucky, all of them, but only with some help or only if you have a fairly simple situation. And I'm going to give you an example. There's a lot of confusion over what a designated health service is and what a designated health service is not. And there's a lot of confusion over whether doctors can directly supervise certain services, taking them out of the definition of designated health service. And there's a new rule that says that if less than 5% of the group volume or the doctor's volume is from one designated health service, it doesn't have to be treated like the other designated health services. So these rules are flying all around. Let's go straight to the presentation here. I'll skip the shameless self-promotion and take it away, Lester.
Good morning. Good morning, Alan. There's nothing shameless about self-promoting. If you don't do it, who will? So there you go. So Alan is both right and wrong in something he said, that the Stark Law and its regulations are very complicated. However, I don't think anyone fully understands them. I think there are people who have better understandings than others, but there's still a lot of vagueness in here, but we do the best we can. Particularly the new value-based rules. But a little bit of background before we sort of get into a few of the recent changes. So the Stark Law, as Alan said, is a statute been around now for quite some time that prohibits physicians with financial relationships from referring designated health services to the entities that they have the financial relationships with. I think we all know that. There's a lot of exceptions to the prohibition, and one of those exceptions is called the in-office ancillary services exception, and that's the exception that most medical practices rely on to allow the physicians in the group, all of whom are going to have one form of financial relationship or another with the group, to refer patients within the group for designated health services. And the reason it's so important is that it's the only exception that applies to either an ownership interest or a compensation arrangement. So for a medical group that has physician owners and potentially physician employees or physician contractors, it's really the one exception they can totally rely on to allow referrals within the group. So it's an important exception. I'm certainly not going to get into all the details of that exception. The exception, what we're going to be mostly talking about today is the definition of group practice that applies to that exception and some of the changes that were made in recent rulemaking. So the Stark Law has a long history of rulemaking, and most recently in December of 2020. And that was the first major new rule in quite a few years, and it probably will be the last major new rule for many more years to come, if there are any. I'm not sure CMS has the stomach to engage in this process again anytime soon. It was very difficult for them, and the product they came out with, while better, still has issues. but nonetheless, it's what we have to live with. So this new rule was published December 2020. The majority of it went into effect January of 2021. However, because of some of the changes that applied to group practices, there was some complaining about that and giving groups time to implement these changes and potentially change their compensation arrangements within the group, et cetera. The effective date for the group practices was delayed until January 1, 2022. Incredibly, that year went by really quickly, and we are now past January 1, 2022. So if you're only hearing about these for the first time and they apply to you, perhaps, you better do something relatively soon because you're out of compliance. And the Stark Law is a strict liability statute. So the fact that it's only a few days past January 1, 2022 doesn't matter. If you're out of compliance, you're out of compliance because it doesn't matter what you intended, unlike other laws like the kickback statute. So let's get into this a little bit more definitively. Here we go. All right. So one of the fundamental concepts in the definition of group practice, and it's actually used in a lot of places in the Stark Law, is something called the volume or value standard, which basically isn't that complicated. It means that physicians can't be compensated, and here's where the rule changes, based on or related to the volume or value of referrals that they make within the group. And before we talk about what that means, want to be clear what a referral is and what a referral is not. So when the Stark regulations use the word referral, it's limited to designated health services. So for a service that is not under a designated health service under the Stark Law, subject to state law, a physician theoretically could be compensated based on how many, for example, that relates to how many EKGs they order, for example, because an EKG is not a designated health service under the Stark Law. If you're in Florida, an EKG is a designated health service, though, under the Florida law. And there are other kickback and fee splitting implications with regard to how physicians are paid and whether their pay is based on how much they refer within the group. But talking strictly about the Stark Law now, the term or the word referral is a term of art and applies only to those services that are considered designated health services under Stark and that are covered, paid for by Medicare and perhaps Medicaid. And I'll talk about that in a minute. So under the new rule, the language now that CMS is using is that the compensation cannot take into account the volume or value of referrals, although the phrases based on and related to still exist in the reg. So I'm not sure that this is a huge change, although there are those who talk about it as a huge change. It does kind of add some clarity about what CMS means in terms of taking into account. So let me give you an example. If a medical practice has a compensation formula for its employed physicians that says you'll get whatever, 50% of the collections for services that you either personally perform or that you supervise, that could be a problematic formula because of the supervision component. Paying a physician based on personally performed services is under Stark is absolutely acceptable, even if that service is a designated health service. The reason is, if you personally perform something, you don't refer it, you do it. That's the fundamental difference. So if you do it, you can be paid for it. The best example of that I can give you in a real life situation is oftentimes physicians in a vascular practice will do their own ultrasounds of a leg or something. They'll actually do the ultrasound themselves. So while an ultrasound is a designated health service, and if the technician had performed the service, the physician couldn't be compensated based on that service. If the physician performs the service, he or she can, again, because it's something they do, not something they refer. So that's why the word supervise can be problematic, because it could include supervision of designated health services, and that cannot be included in the formula because then it would take into account referrals. Compare that to a formula that is limited to services that are personally performed. As I mentioned, those are not referrals, and so that formula would be acceptable. Alan mentioned in his introduction briefly certain services that a physician directly supervises that a physician in a group practice can be compensated for. And those services constitute what are called incident to services, which is another term of art in Medicare, and I don't have time to get into it. If you're working at a medical group, you're probably familiar with it. If not, send me an email, I'll explain it to you. But the Stark Law allows physicians to be compensated based on collections for incident to services that they supervise, that are billed under their provider number, their NPI number. But it's limited to those incident to services. And for purposes of designated health services, there's really only two incident to services. The most significant being drugs and biologicals, like IVs administered within an office, injections administered within an office. However, that does not include drugs dispensed within an office for take-home use. That's something different. The other one are things like physical therapy, but billing physical therapy under a physician has some limitations, but anyway, technically it is an incident to service. And if you meet all of the other requirements for billing therapy as an incident to service, which again is a little bit complicated, theoretically it could be included in the physician's compensation. So that's kind of a quick rundown on this change. So the key thing you need to be really sensitive to in developing a physician compensation formula is thinking about, what might be taken into account if you're making it based on collections, revenue, something along those lines that could take into account referrals. So the second change we're going to talk about is the new exceptions related to value-based enterprise compensation. As most of you, or I assume by now all of you probably are aware, compensation models by Medicare and managed care plans are moving away from, and have already significantly moved away from traditional fee-for-service models to value-based models, because what they want to encourage is not just the provision of more services, but they want to encourage that the services being rendered are of high value, essentially, that they are actually medically necessary, that they improve or maintain the patient's health. And so the compensation is moving away from fee for service. The value-based exceptions under the Stark Law, and there are equivalent exceptions, or I should use the word sort of parallel exceptions, they're not identical, under the kickback statute, and there are new safe harbors under the kickback statute, are designed to protect compensation that flows to physicians as a result of participating in a value-based enterprise. Now, the definitions associated with these exceptions, unfortunately, are circular. When you look at one definition, they include another defined term, and when you try to map them out, it literally could take you the rest of your life, because you really will just keep going in a circle. I see Alan grinning because I think he's also tried to do that and realized that the definitions and the concepts are really difficult to come to an endpoint. But in any event, and so we're not going to get into that in detail. That would take hours. For purposes of today's discussion, I think I want to make two clear points. One, a value-based enterprise isn't a value-based enterprise because that's what you call it. So if in your contract with the physician, you're going to say, in order to increase the value of our services, we're going to pay you for every X-ray that you order. that's not going to fit within the exception. You're not involved in a value-based enterprise typically, unless you're either working with perhaps an accountable care organization or a clinically integrated network that contracts with either directly with CMS as a direct contracting entity or with plans, managed care plans, that in fact have value-based programs and that provide compensation to the group based on the value of the services that the group provides according to the formulas and that they use for determining when to provide compensation to a group. You can't self-declare a value-based enterprise. Now, there are very large groups that have implemented perhaps their own value-based programs, such as I mentioned, those that are involved in directly contracting with CMS. But those are very much the exception and not the rule. So one real threshold point as a group to ask yourselves, am I involved with a value-based enterprise, is unless you're actually one of those few groups doing it themselves, is all right, who am I contracting with that is actually operating a value-based enterprise? Am I contracting, and we'll stick to an accountable care organization, which will share cost savings with their providers. Those cost savings flow from presumably a value-based enterprise. So that's the type of money that we're talking about when we're talking about sharing these monies with physicians in the group. Now, assuming that the money is in fact flowing out of a value-based enterprise, then the compensation can flow. A lot of the rules that apply to START don't apply. So for example, the compensation can flow directly to the physician. The compensation can be based on the volume or value of their referrals, again, if part of the value-based enterprise, and that's where the money is coming from. So there, in the slides, which are really just an article that myself and Hannah Cross, one of my partners, and Nelson Mullins wrote, go into this in a bit more detail. But again, it's quite complicated. And I really strongly urge you not to make your own decisions about whether or not you have money coming from a value-based enterprise unless you're really clear. Get some advice from a competent lawyer, and there are a lot of also competent consultants out there who understand these rules and know how to implement them. One note of caution, however, is that the relaxation of the regs that allow these payments to flow directly to physicians that might take into account the volume or value of referrals only apply to money coming out of the value-based enterprise. Don't assume that anything else will be protected. I have had a lot of calls from clients who are asking me about compensation arrangements and whether they think, oh yeah, well, this new rule will apply. They have nothing to do with the value-based enterprise. And so if they were implemented as they were planned, they would result in non-compliance with START. So you got to be really careful about it. Nothing is waived about traditional compensation within a group that's not associated with a value-based enterprise. So take that into account. Please keep that in mind and be sure before you start allocating money, you're comfortable that you have an understanding of the rules and that you're doing it correctly. Whether you develop that understanding yourself or consult with somebody else. Again, because Stark is a strict liability statute, if you may have intended to do the right thing, doesn't matter. You're going to be liable for damages under Stark. And as you probably are very well aware by now, the primary enforcer of the Stark law are whistleblowers. And so when they find you out of compliance, for example, you make the mistake of assuming that something is value-based when it isn't, and you compensate your physicians based on referrals when it really isn't protected by the value-based exceptions, then you're in violation. And even though you were well-intended, you thought you were doing the right thing, you tried to be careful as you define that term, you did it wrong, you could still be liable. So that's why I'm making such a big point here of treading carefully. And because I've seen and receive calls, like I said, from a number of practices who have tried to apply the value-based rules to non-value-based payments. So,
Lester, let me ask you, is there any commentary or thoughts on whether participation in an accountable care organization known as an ACO and following their guidelines would help a group show that that would be value-based?
well, the money that flows from the ACO to the group is typically going to be value-based compensation. So simply because a group is an ACO provider, that doesn't mean that, okay, we don't have to worry about this and we can compensate our physicians based on their DHS referrals. Because keep in mind, not all of their DHS referrals have anything to do with the Medicare beneficiaries who are members of the ACO. So the money that we're talking about here is primarily the money that is in terms of the share of cost savings that's flowing out of the ACO to the group, not from the revenue that is generated by the ordering of a designated health service for an ACO member. So that's where it gets a bit complicated, and where a group can run into trouble if they think that, okay, we're an ACO participating provider and therefore we're fully protected. That isn't going to be the case.
Lester, do you, I think before we go further, one thing that I was pleased to see in these rules is, if I read them properly, is that these rules, at least for non-Florida, for many non-Florida practices, don't impact Medicare HMO payments or Medicare HMO services, commercial services, cash services. This seems to only apply to Medicare services for traditional Medicare Part B. Is that absolutely correct? As to all these rules that we are.
No, because a Medicare Advantage plan, the rules apply in when a group is assuming risk, either full risk or partial risk, which could be the case with managed care plans as well. And keep in mind, the Stark Law already does not apply to money to Medicare Part C, which is Medicare Advantage. So when a patient in a group is a Medicare Part C patient, the Stark Law doesn't apply. So, for example, I have some clients that are medical groups that 90% of their at least their Medicare related revenue, and they're mostly Medicare or more, 95 or even 98%, come from Medicare Advantage plans. That's what they do. That's how they make their money. And so for the most part, the Stark Law does not apply to them. So it gets a little complicated because of that. So typically those payments are outside of the Stark Law, and those referrals are outside of the Stark Law anyway. That can be difficult for groups when they have a mix of Medicare Advantage and traditional Medicare, which ones apply and which, to what referrals does it apply and what doesn't it? And trying to make that distinction in how you compensate the physician is a zero-sum game. You're going to lose on that if you try to do it. So generally speaking, it's not something that I would suggest unless the group has really sophisticated accounting methodologies. But so Medicare Advantage has its own exception. So that's why this really primarily relates to traditional Medicare Part B services that are rendered as part of a value-based enterprise. The other thing you mentioned that kind of triggered a thought in me is, keep in mind, and I alluded to a minute ago, you do have to keep state laws in mind. Nothing about this waives a state law. So, for example, if you're in Florida, as most of our participants probably are, the Florida Patient Self-Referral Act is still the Florida Patient Self-Referral Act. Nothing about this waives any requirement under the Patient Self-Referral Act, any limitation. And it too is a strict liability statute. Now, the Patient Self-Referral Act doesn't really regulate compensation arrangements with employed physicians, but it does regulate compensation to physicians who have an ownership or investment interest. So please remember that when you say, oh, great, I can just now change all my compensation terms, I can change how I distribute money to the group's owners, I can do this, I can do that, put the brakes on and ask yourself, what about state law? You know, whether you're in Florida or elsewhere, you need to make sure you're still compliant with state law. And these regs obviously don't impact state law. So one last point, I know we are running close to our time, are clarifications regarding the distribution of profit shares. One of the forms of compensation that group practices have been able to use for a long time is being able to share overall net profits from DHS services within the group. And there's always been some uncertainty about what overall profits meant, whether or not that meant that physicians, let's say the group provides, we'll keep it simple, 2 designated health services, clinical lab and x-ray. Does that mean that you have to combine the profits of clinical lab and x-ray and share those as a combined pool of profits? Or can it mean the overall profits from x-ray as separated from the overall profits of clinical labs? And there had been a long-standing difference of opinion about what that meant. So lawyers like me took the words literally when it said overall profits to mean overall profits. It had to be everything. A lot of other very competent lawyers said, no, you could share the profits of the lab with certain doctors and profits of the x-ray with certain other doctors. And CMS recognized that the language was vague enough that it wanted to clarify the language. And the clarification is that, in fact, their intent was and still is, overall profits means just what it says, all profits from DHS. So no matter how many DHS services a group has, if it wants to share the profits with its physicians, it has to pool them. It can't share profits from lab with these doctors and profits from x-ray with those doctors. So that's a key clarification, and one that's probably going to have a large impact on a lot of groups who have been segregating by DHS service. The other things that the regs did impact the pod or the subgroup of 5. As you may know, the rules for a long time have said, well, you don't have to share the profits with the whole group. You can share the profits within a group, a subgroup, so long as there are at least 5 physicians in the group. But again, it has to be the overall profits of the group. So if your group has 10 physicians, you could split them into 2 pods of 5 based on specialty, based on location. Medicare doesn't really say how you can split them into 5. But again, it has to be the pooled overall profits that are split within those 5, and they have to be aggregated prior to the distribution. Another point that CMS makes is that within those groups, within a single group of 5, you have to distribute the profits in the same way within the group. You can't just, let's say you have 5 doctors in the group. You can't give Dr. A profits based on one formula and Dr. B profits based on another formula. However, you can use different formulas for different subgroups. So if you are a group of 10 and you've split into 2 subgroups of 5, you can distribute within one subgroup in one way and another subgroup in another way. Again, it gets a bit complicated. The point being, for purposes of today's talk, which is short and very much at 50,000 feet, is that there have been changes. And if you're distributing profits from DHS, you need to make sure very quickly you look at how you're doing it and does it comply with the rules as they have been revised. Now, one of the big questions that has come up for me, and I know it's come up for Alan because he and I have had to deal with this, is, all right, you have a contract to pay in a way that you thought was compliant in 2021, but is not compliant in 2022 because you've split, for example, the DHS profits into different DHS categories. And so because those distributions typically, obviously lag because you don't know what profits are until you get paid, some of that distribution is going to occur in 2022 when the rule has changed, and now you're going to be distributing profits in 2022 based on a formula that wouldn't be permitted in 2022, but was permitted in 2021. Based on language in the regs and in the preamble, and the slides go into this a little bit, we think that it's acceptable to go ahead and use the formula that was in the contract as it was in effect in 2021, because the exception applied when the referral was made, and the referrals were made in 2021. Again, we go into this a little bit more in the slides, but again, I think the takeaway for today is that assuming your formula was compliant prior to January 1, 2022, but would not be compliant under the revised rules, the lagging profits that you're going to distribute from 2021 could still be based on the 2021 formula. Now, a whistleblower could take issue with that and try to bring a case based on that or in part on that, and ultimately courts then will determine whether or not what we're saying is correct. But we think it's reasonable. The really conservative approach is to say to the doctor, sorry, the rules changed, we can't do it that way anymore. And that's an option, certainly, if you want to be really protected. Say, no, we have to distribute these lagging 21 profits based on the 2022 rules. Obviously, you're going to be in somewhat safer territory. But again, we think that a reasonable approach would permit the use of the 2021 formula, assuming it was compliant. So I think, Alan, that brings us to the end.
Lester, let me just give an example to make sure everybody is on the same page. So if you had two different offices with 7 doctors in each office, and Office A, they shared the profits from ultrasound one way, Office B shared the profits from their ultrasound another way. Now they all have to share the combined ultrasound profits from those two offices, but the doctors in Office A may get the division one way, the doctors in Office B may get the division in another way.
That's still acceptable. Yes.
Yeah. So, and then all of the DHS have to be shared in the same way. You can't share X-ray one way and blood lab another way.
Correct.
And it has to be based on what I call the net profits, which there's 97 different ways to calculate net profits. So just ask your CPA to come up with some reasonable way to do it. And then, Lester, if you have a designated health service that's under 5% of the practice's Medicare revenues and under 5% of any doctor's Medicare revenues, that doesn't have to be in the mix. That can be allocated however you want.
Well, if the group's revenues totally are 5% or less based on DHS, then your basically Stark doesn't apply. And there are some groups who might have an X-ray machine, for example, that doesn't generate, much money, that would fall into that category, but not many do. And you do need to make sure you calculate it correctly. And keep in mind that both the professional and technical revenues are considered DHS. So if the technical revenues might be 4%, but when you add the professional component, it becomes 6%. You no longer are in that spot.
But if I have an X-ray machine that's 3% and an MRI machine that's 20%, do I need to account for the X-ray profit the same way as the MRI profit?
Yes. Yeah.
Oh, okay. It's tricky.
It is tricky. And I talk to clients about the Stark law probably every single day and probably multiple times a day. And I can tell you that almost every time that I do, I actually pull up the reg on my computer and look at pieces of language because it is that complicated. And while anyone can remember the basics, I don't care how much you do it, because each word can become so important. And because it's a strict liability statute, and you got to be sure you get it right. I mean, I'm always looking back at the regs, or looking back, even saying I'll need to look at the preambles, or look at this or look at that, because it is so complicated. It isn't something that you can take off the cuff.
What if you have a legally binding employment agreement that says we will share it this way, and now that's illegal? If the agreement doesn't have an automatic adjustment clause.
It's an illegal agreement, so it's unenforceable. So,
wow.
So if let's say you have an agreement that is not START compliant, and so you tell your physician employees, hey, I know we said in this contract we're going to pay you in this way, but we can't. So sad, too bad. We're going to keep the money, and they sue you. You actually would have a defense that the contract was unenforceable because it was in fact illegal. It would have caused the group to violate the law. Therefore, the contract is illegal, and that provision in the contract is illegal, and therefore unenforceable. So that's kind of how that would typically go anyway.
Therefore, the non-compete provision and the non-solicitation provision under that agreement may be unenforceable by the employer.
Maybe, I mean, but by not paying them based on the illegal compensation provision, I don't know that they breach, there's necessarily a prior breach. I mean, it could, that bonus provision could be, if it's a bonus provision, it could be, we're getting into too much legal chat here, but that bonus provision could be severable. So a court could say, the rest of the contract is fine, but I'm not enforcing the bonus provision. However, if the whole compensation provision is illegal, and so by throwing out the compensation provision, now there's no methodology to pay the physician, then the whole contract, may be unenforceable. So it gets tricky, and it gets into, unfortunately, a lot of lawyer mumbo jumbo, but yeah, it creates, can create a lot of issues. I think we're done, Alan. This was a very 50,000-foot overview, but hopefully it alerted you to some key points that you need to at least follow up on and make sure you're still in compliance.
Right. If you want more information on this, you can email Lester or me. You've got our email addresses there at the bottom. Lester, thanks as always for all the help you provide to our clients and our friends. And thanks for being such a leader in this industry.
Thank you, Alan. Thank you for all you do. And we'll talk to you guys later.
All right. Have a fantastic rest of your afternoon and evening. Thank you.